All right, so on behalf of the Federal Bar Association and the Ninth Circuit and the FJA, I wanted to welcome everybody to this program on a Friday afternoon. So thank you everybody for taking the time out of your schedule and on this Friday afternoon to join us for what we hope will be a very educational and informative event, really looking at the evolution of the 14th Amendment over the last 150 years and how that has affected really equal protection in the education context. Before I get to introducing our panelists, I really wanted to focus on one of the main reasons why we are here today. And that is that there is 2 essay and video contests that are being held right now. And one is on behalf of the Ninth Circuit, and one is on behalf of the FBA and the FJA. And this is really focused or geared more towards high school students. And it asks these students what equal protection means to them. And so these respective contests have been sent out to high school students across the county, to all the different schools in San Diego. And what we're going to do, and what we're doing now, is we're broadcasting this event, we're videotaping it, and then it's going to be presented and posted on the court's website for access by the students. And so what I urge all of you to do is, if you have a high school student, who's a neighbor or a friend, please pass along this information to them. There's flyers for both of the contests. They were also provided as part of your written materials at the very end. There's extra copies up here. Please feel free to take one and pass them out to a high school student that you know of. These contests have money prizes, so especially if they are a junior or senior with their eye towards college, this can be very helpful in helping that individual accomplish that goal. So that really is the reason why we are here, in addition to educating us all on the evolution of the 14th Amendment. So with that, I'm going to introduce our panelists. So we have 2 speakers, 2 law professors from local schools, and then a moderator who is a assistant United States attorney. So our first panelist is going to be Professor Roy L. Brooks. He is a distinguished Warren professor from the University of San Diego School of Law. He comes from very high law school, so he graduated from Yale. He was the editor of Yale Law School. He is the author of more than 100 articles and 20 books, many of which received national recognition. He has been teaching for approximately 38 years. Prior to arriving at the University of San Diego School of Law, he clerked for a federal judge in Philadelphia and practiced in the area of corporate law. Most notably, at least for me, he was one of my professors at the University of San Diego, as I would assume maybe some of the individuals out in the audience. So welcome, Professor Brooks, and thank you so much for being a part of this panel. The second professor is the professor on the end, and that is Professor Maurice Dyson, who teaches law at Thomas Jefferson School of Law. He teaches a variety of courses, including education, equality in the law, torts, global justice, self-determination in the law, and legal writing. He's a graduate of Columbia Law School, and he practiced in the area of mergers and acquisitions, securities and leverage buyouts, at a national firm. He has also participated in landmark school finance litigation and in federal civil rights enforcement as a special projects team attorney for the United States Department of Education Office for Civil Rights. He's also published a book on education policy and several articles on education and civil rights. So very well suited to join our panel today. Also, hopefully in the audience is some of Professor Dyson's students from Thomas Jefferson School of Law. So if you are here, welcome, and thank you very much for joining us today. And then our esteemed moderator is Chris Tenorio, who is an assistant United States attorney in the Southern District. He specializes in the investigation of civil rights crimes and has helped prosecute some of the largest modern-day slavery cases in the United States, which resulted in national attention to the human trafficking epidemic. So thank you, Chris, for joining us and for serving as our moderator today. After the presentation, I hope that all of you will stick around for a reception that will be in the jury room immediately behind me. And there is some panels that are set up covering the evolution of the 14th Amendment and really highlight some of the cases that the panelists are going to be talking about today. So I really encourage you to grab some food, talk to some of your fellow colleagues, and then really to take a look at some of these panels and see the information on them. Last but not least, I couldn't be up here as a representative of the Federal Bar Association without encouraging you to become a member. So if you aren't a member already, please visit our website, fbasd.org. Check out some of the benefits that we have to offer. And again, welcome to the presentation. And without further ado, I will turn it over to our panelists.
All right. Hello again. I was very eager to start. Again, I'm Professor Dyson, and I'm privileged again to present to you some very historical landmark cases that have transformed our nation. As you've seen in your program, the Mendez versus Westminster School District case was a paramount case that has addressed educational equality well before Brown versus Board of Education. It is a case that has been lost in the history books and has been relegated to obscurity. And I think that we need to revisit this case and understand its important implications, not only for Brown, but for the restitution protection jurisprudence. So going forward, I want to proceed with giving you a little bit of context about the social dynamics leading up to the Mendez case. In California, where the Mendez case was decided, we had segregation throughout the state. It was required by law that Asian Americans would be segregated. And it wasn't just Asian Americans. We also recognized that Native Americans as well would also be subject to statutory segregation under state law. Now, understanding the context of this wasn't always the case, right? Before 1855, we had more inclusion. Of course, Spanish was the official language as well as English in the state of California. We did recognize that under law, Mexicans were legally considered white. There was not this wholesale treatment under the law of treating Mexicans differently, although socially the dynamics were very different. You can see there that we had quite an atrocious history in this country of how we relegated Mexicans to a second-class status, even though they were citizens of the United States. And the Mendez, of course, who were Puerto Rican, were, of course, Mexican citizens, but still relegated to the second-class citizenship status. And so that didn't really quite change for quite some time. Even though they were legally treated as white, understand that the context of what this meant was that we had very little recourse legally in our courts to actually address discrimination against Mexicans. The idea is that if they were legally white, then there couldn't be discrimination against them because they were of the majority race. So this kind of paradoxically created a situation in which Mexican Americans didn't have effective recourse in the courts. And in the context of growing up, you can see in these different communities, there were racial restrictive covenants that excluded Mexican Americans from actually participating in any neighborhood purchases of homes. They were, of course, written into the deeds where they said absolutely no Spanish or Mexicans in our neighborhood. And we lived in substandard housing, of course, and it was a pervasive social attitude that Mexicans were inferior. There was something called Mexican Mondays. Mexican Mondays is where Mexicans were allowed to use the public pool, and then, of course, after they used it, they would drain the pool, scrub it clean, so that on Tuesday, Caucasian Americans can use it next. This was a social pariah that we grew up with, and that segregation took place all throughout Orange County. It was in this context that the Mendez have come to seek redress in the courts. It happened, of course, when they moved from Santa Ana. They actually got a ranch, and the ranch that they actually rented out was done as a favor for a Japanese family that would lose their land because they were forcibly interned into an internment camp under the executive order of under the executive order of President Roosevelt. And so, while there, they sought to enroll their daughter, Sylvia Mendez, into local public school. And then, of course, it wasn't just Sylvia, there were other plaintiffs as well. 5 other families joined in as well. And we'll talk a bit more about those. But when Sylvia Mendez, of course, came in September 1943, she was basically 9 years old at the time and sought to actually get enrolled into the 17th school in Westminster. But it wasn't the Mendez family that, at least her parents that had brought her to school. It turned out to be her aunt, Soledad Villaduri. You can see there. Now, when she brought Gonzalo's kids, along with her own, to the Westminster 17th Street School, she was seeking to enroll them when she was told that she could not. Essentially, that she had to go to the Mexican school 10 blocks away. But for her own children, as you can see, they were allowed because they were fairly light-skinned. And they were allowed basically under essential racial passing policy, that if you can pass the complexion test, then you can be admitted into the school. And so for her own children, who were fairly light-complected, they were allowed to be admitted to the school, but of course, Gonzalo Mendez's children were not. And that played out all throughout this country, by the way. Even if you go to Louisiana, you might still see today that there's a brown bag paper test. If you're darker than a brown bag, you're not admitted into certain establishments. So it was something that was understood to be unofficial as well as official. And in fact, as you can see here, there was a policy where you can see the admissions criteria were very stark. In Anglo schools, students had to have light skin, color eyes, light hair, blonde or red hair, English speaking and English first and last names. Mexican schools, their children who had dark hair or brown skin or brown eyes or brown or black hair or Spanish speaking capability or had Spanish surnames, of course, were excluded. And so you can see that the students here on the right were allowed in, where the students on the left were not. But they had hoped to go to Westminster School. And as you can see, palm trees, manicured lawns, well-updated facilities, updated textbooks. But that's where they were denied. Instead, they were sent to the Mexican school 10 blocks away, and that was a Hoover school. Now, the question really was this equal? In the opinion, you will see that the judge indicated that there were equal facilities, but in fact, in reality, it was not. And that was well understood in the neighborhood. There were outdated books, substandard conditions in the school. It was next to a cow pasture where there were flies. There was an electrical fence that divided them where the students sometimes got electrocuted. The teachers were not as aptly prepared. And that was the case all throughout, whether it was the Hoover School or the other schools that were mentioned in the case. And what we see as a dynamic there, we see played out even today, unfortunately. So we see, for instance, racial and gender stereotyping that takes place in education. So for instance, when you see Ms. Mendez talk about her plight today, it's very compelling. She talks about how we weren't learning math, we weren't learning science, we weren't learning things that would help empower us. Instead, we're learning to sew, stitch, and quilt. And that kind of dynamic has played out today when we're talking about schools that are built for women and all schools that are for boys. Some of these gender stereotypes continue to play out. So when Gonzalez was told that his children were barred, of course, he tried to speak with the superintendent to negotiate with them, and of course that didn't work. The parents got together and tried to sign a petition to force the school district to let them in. And when that didn't work, of course, they filed a lawsuit. And the suit was landmark. As we pointed out before, it was the first that actually decided, at least at the district level, that an equal protection clause forbade this kind of discrimination. And that was key. Now, I want to point out that here the lawyer was Mr. Marcus, David C. Marcus, was a Jewish attorney, married, of course, to a Latina, and he was committed to the civil rights movement. He knew that his job was broader than just coming to work and collecting a paycheck. He understood that there was a social importance to what he was doing, that history will not be the arbiter of progress, essentially, because history is essentially neutral. Time is neutral. It takes efforts, it takes perseverance to actually push history forward. At that time, of course, the suit was joined by Thurgood Marshall, and together he worked with Robert Carter to devise a strategy that would lay the blueprint for Brown versus Board of Education. In fact, when Robert Carter was interviewed about this case, he was actually made clear that in the brief, this was a test brief where he was testing these ideas that would later be the seeds for Brown versus Board of Education. And again, he sought to tie not just the Mendez, but these additional plaintiffs as well. So with these 5 other families, there was also a broader vision to expand the suit to 5,000 Mexican and Latin descendant students that were being segregated in the public schools. The case came before Judge McCormick, and Judge McCormick was, again, in unprecedented ground. No one had actually said that separate but equal is inherently unfair. no one had said that Equal Protection Clause forbids this kind of discrimination, we were still in the landscape of Plessy versus Ferguson in 1896. The attorney that was arguing for the schools, of course, had a dissertation where, surprisingly, he had made some statements about Mexican Americans being contagions of disease and communicable disease and unfit and of a lower stock. And so it was interesting that some of the social science research that he had, so-called social science research that appeared in his dissertation, ended up also appearing in the trial as evidence against why Mexican Americans should not be admitted. And the testimony from the school district was quite deplorable. There was no justification for this kind of discrimination. On the other side of the case, we had social science evidence that was presented by the plaintiff's attorneys. And again, this was very powerful. I mean, much talk has been made about footnote 11, Brown versus Board of Education, about the whole black doll, white doll test that Kenneth Clark had put into place. His former psychologist trained at Columbia University and looked at putting a black doll in front of a black child and a white doll and saying which doll was prettier, which one was smarter, which one did you like better? And invariably, the black doll was always chosen for the one that was uglier, that was not smarter, right? And the white doll was chosen by the black child as being, of course, prettier, smarter, more attractive. And so that was, again, a great step forward in including social science and jurisprudence. That was from the school of D. Roscoe Pound. But it was really in Mendez where this social science evidence was really being introduced. And so they presented evidence that was not that just segregation is a badge of inferiority. They recognized in this case that the effects of segregation had an effect upon education. And so we have both a legal theory and both an educational theory. An illegal theory in the sense that, again, the separate but equal doctrine cannot stand, that every time that there is separation in society, invariably inequality follows. I think for this reason that Brown versus Board of Education, the NAACP had stipulated that the schools were equal. Again, they weren't equal, and everyone knew that, but they were really trying to squarely address the issue of race and racial equality. So Judge McCormick agrees with that, and he recognizes in his decision that the evidence clearly shows that Spanish-speaking children are retarded in learning in English by lack of exposure to the use of the language because of segregation, and that commingling of the entire student body instills and develops a common cultural attitude among the school children, which is imperative for the perpetuation of American institutions and ideals. It is also established by the record that the methods of segregation prevent in the defendant school districts foster antagonism in the children and suggest inferiority among them where none actually exist. And he continues to go on. The Equal Protection Clause pertaining to the public school system in California is not provided by furnishing separate schools, the same technical facilities, textbooks, and courses. That there has to be essentially social equity. Social equity or social equality, again, was very radical for that time for any judge to say. And so when he looked at the evidence and he said, why aren't you segregating these students all the way up to the 5th grade? After the 5th grade, then they can come together and study? So you're saying that in the 6th grade that they can actually come together and be educated in an interracial format? That would seem to suggest, of course, that this rationale for segregating in earlier grades really is kind of fallacious and it's unpersuasive. And he made that same critique with the Hoover School. 3 of the school districts, of course, segregated up until the 6th grade, and 2 of them segregated, of course, up until the 8th grade. The school district said, okay, well, we're not trying to discriminate on the basis of their national origin. There are just language handicaps. They need to have that time apart to, of course, learn. But what the judge found was, of course, that the school districts had never administered a language proficiency test. They never assessed their language ability before they placed these students into these segregated schools. It was really a sham, a pretense, and that existed throughout all the schools. So it was a landmark decision that was made, and it was a pivotal one in the sense that we have now laid the groundwork for progress and board. It helped to put a death into Plessy versus Ferguson. And of course, we talk a lot about Brown versus Board, but again, Mendez has been a bit forgotten. And even more forgotten than Mendez is, of course, the Roberto Alvarez case. It was decided in 1931 in Lemon Grove, San Diego. for the first case where a judge said that segregation, of course, is unconstitutional. And it wasn't, of course, just the Roberto Alvarez case. It was the Lopez versus Sacone case. And again, attorney David Marcus had argued that case successfully, showing that the discrimination that occurred in public parks and pools was unfair and unequal and a violation of the Equal Protection Clause. And it was for this reason that, of course, the Mendez had hired this attorney to represent them in their case. While this case went up on appeal, of course, there was an affirmation by the circuit judge, of course, recognizing that there was a violation of the 14th Amendment. But it wasn't really quite clear that it was based on the same kind of profound visionary rationale that McCormick used. Judge McCormick understood the idea of social equality being an essential ingredient for success. So the circuit court looked at this, they decided that, well, yes, there is a violation of the 14th Amendment, but it was because that there was no basis for them to segregate based on the current statutory scheme in California. After the circuit court affirmed the district decision that there was a violation here of the Constitution, there was another that you might remember from history, Earl Warren. Earl Warren, of course, at that time was the governor of California, and he signed Assembly Bills 1375 ending segregation in California. In fact, after that, California was the first state to desegregate in the nation. And of course, other states were very eager to follow with our success and figure out, what did we do right? How do we do it? And it's important to note that Warren was not just pivotal in that piece of legislation that helped to do away with the segregation of Asians and Native Americans in the state of California, and affirming that, of course, the Mendez decision was right. He was, of course, nominated to the Supreme Court, and that was not a minor development, because certainly we recognize that when he was on the Supreme Court, he had a key role in Brown versus Board of Education. Of course, he made a point that establishing a unanimous vote was important, because when it comes to integrating, you don't want to have a nation that flip-flops back and forth between desegregation or no desegregation, desegregation or no desegregation. He wanted to get an affirmation from each of those justices with unanimous decision to send the most powerful message that this was an important mandate for the nation to follow. And so we recognize Ms. Mendez, of course, in many different ways. You can see the federal postal stamp there, and she's really quite proud of it. And of course, the school's named after her, and she really was recognized for what she's done. And we can be very proud of that achievement. We can certainly recognize that there is importance. But there is a progress stall, right? We can look at what's happening in our public schools, and we can see that the schools are resegregated, right? And it is a constant struggle. Frederick Douglass said that without struggle, there is no progress. That those who would advocate for freedom and depreciate agitation would rather have crops without plowing the ground. They'd rather have rain without the thunder and lightning. They'd rather have the ocean without its many roaring waters. That power never conceded nothing without demand, and that it never did, and that it never will. And that is the same notion that we have to keep in mind, because what we see throughout history has played out before. In Reconstruction, we had amazing progress. The 13th Amendment was passed, right? It abolished slavery, except as a punishment for crime. The 14th Amendment was the Equal Protection Clause, and the 15th Amendment granted blacks the right to vote. It was an amazing time with Reconstruction. From 1865 to 1877, African Americans and minorities made significant progress in this country, and they held even elective office. But of course, there was a recurring backlash, right? The federal troops were moved from the South. The deal was made between the North and the South. President Rutherford B. Hayes was elected. And of course, all the progress that was made was starting to be eroded gradually. And we see that. We see that even more so today. When we had busing that was mandated, for instance, what was the reaction in this country? It was not one of welcome. In fact, it was outright hostility. And not just hostility, but anger and violence. Buses were overturned. People were threatened with their lives. And this happened with children, it happened with adults, it happened in the North, in Boston, it happened in the South. And so we see that backlash whenever there was progress made. We see that backlash even in general efforts to integrate in our society. It is not something that has come at a light cost. And that backlash has also resulted in a quiet reversal of Brown versus Board. It has reversed many of the progress that we've made. Much of the progress that you can see here, these cases have undermined it. Milligan versus Bradley. says that we can't have any desegregative order that includes the suburbs, right? We recognize that when those consent decrees were passed, there was white flight to the suburbs. And what the court said there is, well, you can't chase after them. And we said, well, Your Honor, the state has created this segregative statutory scheme, and now you issued an order to comply with the Equal Protection Clause, and now you are allowing non-compliance with the consent decree willingly? So Milliken, of course, put a major dent in, of course, the Brown promise. Same thing with Milliken, too. Brown versus the Board of Education of Oklahoma versus Dow. We recognized there that, of course, there was a desegregation order that should be ended, but of course the measure that was used there, the standard that was used by the court there was good faith. If the school districts are complying in good faith with the consent decree, that's all that really matters. Whether there's actual desegregation on the ground, that's another story. So it really raised some questions there. And then you see, of course, in Freeman versus Pitts. In Freeman versus Pitts, we have, incremental, right, compliance. In other words, what the court was essentially saying there is, if you try to desegregate the transportation, extracurricular activities, and teaching assignments and pupil assignments, you recognize that if you desegregate in one area, take a snapshot, leave it alone. Now work on this other area, take a snapshot, you got compliance there, or unitary status there, you're in compliance, you're no longer segregated, great, take a snapshot, let's leave it alone. And they could do this in a compartmentalized fashion, in a way that would certainly assure desegregation would occur again. And of course, in Missouri versus Jenkins, the plaintiffs really were trying to address the educational vestiges of segregation. And that's important, right? Because it's not just pupil reassignments, right? The whole point of this was to try to have educational equality, but what is educational equality without educational quality? And so we were hoping to embrace this notion that we would have a really forthright address of the educational vestiges of segregation, and the court said, no, that's not possible, right? You want to have those magnet schools, you want to have these higher teacher salaries, but that's going too far with your remedial authority, and we won't allow it. And so we have a rapid backlash, and the resegregation is real. So as you can see, there's a process, there's a progress, there's a pattern that's happened, right? Every time progress is made, it's pulled back, right? Reconstruction, then we pull back, right? You have integration, and then we pull back, right? And we have the first African-American president of the United States, and then we pull back. And it is a major backlash. It is a history that repeats itself over and over again. And so we can compare the kind of violent protests when James Meredith was trying to integrate University of Mississippi, or the violent protests at Brandeis University, or in Boston with the students on the streets. It's a cycle that tends to repeat itself. So one of the lessons that we learned from the Mendez case, that once you have a mandate, that you have to enforce it, you have to fight for it. I was fortunate enough to work with the CFE versus State of New York case in New York, where we found that $15 billion was being cheated out of the students of color in New York City schools, and it was being diverted upstate. Only 3 people in the whole state actually knew how the funding formula worked, and it was revealed that they reverse engineered the outcome that they wanted. And so the idea there was that we recognized that the same problem still exists, the same patterns of discrimination. When we did get a victorious mandate, we had to fight for that. Once the court did grant that order, we had to fight to get it on appeal. We had to fight to, of course, have the state legislature grant funds for it. And then once we get the legislature to agree to it, which they really, really want to, raising taxes is certainly like the third rail of politics, no one wants to touch that. You have to then fight on the ground to make sure that those funds are dedicated to the right constituents, the folks who have fought for that litigation. So I hope that we understand that the promise of Mendez, the promise of Brown, really is one that it is a vision that we need to hold and embrace, but it certainly is one that is slowly, if not rapidly, deteriorating before our eyes. In Lau versus Nichols, we had a situation where, of course, we had San Francisco public schools were essentially shutting out Chinese students across the country. They weren't really allowing them to participate meaningfully in the public education system. Why was that? Because they didn't actually speak English, right? And here again is the role of the socially conscious lawyer. It is a lawyer that goes beyond their 9-to-5 job and pursues a vision that is greater than themselves to make a big difference in this world. If you're not making the difference, what are you doing, right? And so, Lau talks about how he tried to work with the schools to try to actually learn, but the real background of that was that the school was trying to offer at the last minute some piecemeal remedies to him to provide bilingual education to try to moot the case before it actually got to court. And so the difficulty, of course, was that would certainly was a deal that was struck with Lau, but it didn't have an impact upon the rest of the class. In the Mendez case, it mattered that the school district did make an offer to the Mendez family at some point and said, we'll let your students in, we'll let your child in. But no, we had to look broader than that. While there was an individual benefit, we had to think about the collective benefit overall. And so we recognized that in the Lau case that there was a need, of course, to have uniform and equal access. But what does uniform and equal access mean when it has a detrimental impact? Just because there is a uniform law, it might seem that it is equal on its face, but it has a disparate and differential impact in effect. And that's what the Lau case points out to us, that we recognize there is a nexus with language disability, in other words. That treating every student the same essentially shuts out these Chinese students who cannot speak English. By treating every student the same, you are essentially foreclosing their inclusion in the education system. So it turns out that Lau was actually brought, decidedly by the Supreme Court, I should say, under the Equal Protection Clause that was brought under Title VI of the Civil Rights Act. And so that was quite significant because it's the one tool that we really have that tries to address differential disparate impact, where there's a law that looks uniform, it looks equal on its face, it reads clear, the rhetoric sounds nice, but in effect you can see that it has just the opposite, that it disproportionately burdens other students more so than others. And under the disparate impact test, we recognize there's a tripartite test, right? Is there an adverse disproportionality impact upon a group of students? Yes. Then we go to the second prong of the test, which is, does the school district have an educational necessity to justify that? And if they can hold that burden, then the burden shifts back to the plaintiff and say, okay, well, can you show that there are less discriminatory alternative feasible means to achieve the same result? Yes, right? Provide education to these students. 1,800 students that were shut out of this case because they weren't able to effectively participate in the classrooms. They didn't understand what was being taught, what was being said. And that mattered because there were significant major demographic changes in Chinatown. And the ability to speak English played a significant role in the hostility that was seen. The Chinese Americans that did speak English were in direct hostility with those recently arrived immigrants from China who did not. And the ability to speak English meant, of course, that there was an invitation to be part of a membership, right? To not be part of an outsider. And so these 1,800 students were essentially left bereft. They were not left with any means to understand their language. Again, what would it mean to actually have books in their own language, to have instruction in front of their own eyes with a person that speaks their own language? The interpretive guidance, of course, that we learned from Title VI is that if we do not provide accommodation, as we think of it as in disability law, if we don't provide an accommodation on the basis of language, then we are essentially engaging in national origin discrimination. And that reminds us again of what we saw in Mendez, national origin discrimination. The California Education Code requires that English be taught in the classrooms. It is the language that is required. But the Bilingual Education Act, of course, didn't really have much effect, besides being repealed, or didn't really address the issue of these students. The funding was limited to only those who were in the ages of between 3 and 8, and it had no benefit for these students in these classes. So Mendez, of course, tells us that there is a significant constitutional violence when you have even sometimes implicitly, right, this kind of segregation based upon the pretense of language. And language segregation gets revisited again here in Lau versus Mendez. Whether they're in a classroom or not, they're segregated from a meaningful educational process. But the standard here was comparing the access to the education system based upon English speakers How well could they learn the material compared to their English counterparts? And that was a standard. And that's a golden standard, right? Language as a proxy for discrimination is real. If you try to discriminate on the basis of language, you are certainly discriminating against on the basis of national origin, and you are shutting them out of the education process. Now, in the concurrence of this decision, the judge recognized that numbers were at the heart of this case. He recognized that we had 1,800 cases, 1,800 students here that were the plaintiffs in the class, but had there been maybe 10, 15, 100, maybe even 200, the judge makes clear that that might not be the case. He says, for me, the numbers are at the heart of this case, and the concurrence is to be understood accordingly. He's definitely conditioning his concurrence on this recognition that this is not something that is going to be applied indiscriminately. When we look at traditional bilingual education, it's significant today because we recognize that, yes, the students can actually benefit from learning in their own language. In most educations that are traditional bilingual education, they have up to 3 years to learn, and then they are immersed into the English-only class. When it comes to structured immersion, especially like the kind that we have here in California, and we have that thanks to the Ron Dunn's initiatives, we have structured immersion where the student who comes to this country has 1 year of instruction in their native language, and if they don't get it, too bad, you're going to be admitted into the English-only class, and you have to learn from there. That is a sink and swim approach that has not actually yielded the kind of beneficial results that you might think. There was the rhetoric, and then there was the outcomes, and the outcomes do not match the rhetoric. A better model of bilingual education that has spurned from the Equal Protection Clause is dual immersion. It is not mandated by the Equal Protection Clause, but it is certainly something that we look at. When Castaneda versus Pickard was decided and embodied in the Equal Educational Opportunity Act, it recognized that there has to be effective educational methods that help to close academic deficiencies based on language. And dual immersion is significant. Here in the classroom, you have the teacher who speaks maybe Spanish and English. And he or she is teaching in Spanish and in English. And so the non-English speaking students are getting instruction in their language. At the same time, they're also learning English. And the English-speaking students in the classroom are learning Spanish at the same time. And so this kind of dual immersion model has been very effective. And it has led to the closing of the academic achievement gap. And not only that, it has had some beneficial impact upon other models in the curriculum. So for instance, we see that when dual immersion is submitted, that it has some benefit for mathematics. It has some carryover for musical instruments. So it is quite significant when we think about some of the benefits that we have from dual immersion. Okay, I'm just going to cut that short, but the main issue that we are addressing today that we face after these these landmark decisions is again a pullback, right? Whenever there's progress made, there is pullback, there is a backlash. And Alexander versus Sandoval is certainly a retrenchment in that case, in the sense that we have the Supreme Court that says that there is no right to bring a private action suit under Title VI. And if you don't have a class action right to bring claims under Title VI, it can significantly diminish your right to be able to effectively advocate. These claims are best brought before the Office for Civil Rights. But we have that precedent out there. We have others as well. But the notion that we have some resistance to the disparate impact test is real, right? The idea that we can prove discrimination on the basis of intent is difficult because no one is stupid enough to admit that they were intending to discriminate. And if you can't prove it, you don't have the smoking gun, and you can't use disparate impact to show the adverse impact that it has, and that the policy is a pretense, then what leg do you have to stand on? And even more so, we have to recognize that even if people do not intend to discriminate, there is implicit cognitive bias where people discriminate and the effect is just the same, even though people do not have the intent to discriminate. So while the perpetrator or the policymaker does not have the intent, with respect to the victim, with respect to the recipient of that behavior, it is the same effect. In Andrew versus Douglas, we see that we had a very determined group of parents who were seeking to revise the individualized education plan that they received from their school district with regard to their child, Andrew F. And the individualized education plan is essentially an agreement between the parents and the school district to provide disability accommodations for their child. And over a period of time, the family was really questioning the school district and growing a bit skeptical about these IEPs because their child was not making progress at all. Right? And so over time, the school district kept resubmitting new IEPs after IEPs. After 5 IEPs, they were recognizing, well, this is not really cutting it, right? You know, they grew frustrated and they recognized that there needed to be some significant change. And so this complaint was filed where after they did try to seek some unofficial negotiations and then official mediation and then taking that to the local education agency, this complaint was brought to the Supreme Court. And it was, again, a testament of perseverance because the lower courts had already sided with the school district, all the lower courts below. And so to continue to persevere, they really tried to ensure that their child would get the protections that they wanted in their IEP. What essentially happened was that the Andrews were so frustrated with their school district that they decided to move their child out of the public school and have them go to the Firefly Academy, a private school, and then have that reimbursement of tuition paid for by the local school district. Now that is a provision that is allowed under the IDA. It happens that most affluent families know about that provision, but it is not a provision that is widely publicized. It is not a provision that most parents do not know, especially in low income and communities of color. But they knew that there could potentially be tuition reimbursement if the home school district was not providing adequate accommodations. The school district tried to push for the standard of minimal progress. Well, he's doing well, progressing from grade to grade. What more do you want? That should be the standard. But the parents were, of course, really looking at this success that the child had. You see, when Andrew was in the old school district, he was screaming in the classroom. He was climbing over tables, he was climbing over people, he was running away from school. When he went to the Firefly Academy, he was actually doing well, right? And he started to be very socially well-adjusted and academically improving. And so they looked at those ingredients of the IEP and they said, you know, we want our child to continue to do well here. And the school district recognized, well, you know, good is enough, right? Good is enough. And as long as they're getting a free, appropriate public education, that would be fine. But the case was, of course, reviewing the Raleigh decision. In Westchester County versus Raleigh, this was a decision that was trying to wrestle with what level of adequacy is truly adequate for an IEP. How much level of support does a school district actually have to provide a child with a disability? And it recognized that an IEP just has to be reasonably calculated, right, to at least help the child, you know, achieve passing grades and advance from grade to grade, right? And that had to be tailored to the child's circumstances. What are the child's circumstances? What does that mean? Does it mean her potential or full capacity? Does it mean the maximum ability? Right? How do you determine that? The Raleigh decision was recognizing, well, it's none of that. It's not the highest capacity, it's not the highest ability. It is just providing some educational benefit. And so that was the argument that, of course, the defendant school district used in this case. And the court was a little suspicious about that. So, well, now we have to think about IEPs. It is true that there has to be some educational benefit, but what does that mean? It has to be reasonable. It may not be ideal, but it has to be reasonable. We have to recognize that there can be, you know, some distance between what the parents want and what the school is able to provide. What kind of progress is enough? Well, they said, well, just minimally adequate, right? And the Supreme Court recognized through Chief Justice Roberts that that was not really an effective standard. The de minimis standard was rejected, right? We really didn't recognize that, even though the child has some educational benefit. What that actually means is not quite clear, but we know that it's not this. It's not just merely passing from grade to grade. And it's not just merely just getting by. Andrew's parents claimed, well, we should compare his progress to that of non-disabled students. Whether your child is getting meaningful access to the education system compared to their non-disabled peers. And that was the argument, of course, that, you know, Amy Raleigh used in the Raleigh case. It didn't really succeed there either, and it didn't succeed here. So it's not quite clear what a free appropriate public education means in terms of providing an adequate IEP for a child. The court recognizes that there's really no bright line rule, and it refused to determine a specific test that would actually help. No specific test was given, but the court made clear that courts are not free here. They don't have a free hand to decide what is best for the children, right? That we have to give some due regard, due deference to the authorities of the school district to determine what is appropriate. And so we also recognize that, this is a complex matter, that schools are best positioned to address these questions rather than courts. They're too complex, they're too difficult, right? And of course, it is a matter for the states. That's the assumption. But what's happened since, really? What's happened since and what's happened before this case? You mean to tell me that when the federal government passed Title I, right, the Public Education Act, Equal Educational Opportunity, Act, the No Child Left Behind Act, right? The Race to the Top, the Improve America's Act. Improve America's Schools. You would say that the federal government has no role to play. The federal government has intervened quite effectively and sometimes very ineffectively, but very pervasively, we could all agree, at the state level when it comes to education. And we could also agree that because education is a very complex issue, it has not stopped the courts from intervening. And so we recognize that that's an issue. And I can say as a school finance attorney, we look at this all the time. We go into these states and we look at what is an adequate education. And it's not hard to figure it out. In the New York case, we said, well, let's look at what a person has to do. They have to vote in a jury box, which means they have to know about division of governments, right? The separation of powers. They have to be able to analyze DNA evidence, which means they have to know something about science. And when there's a fraud case from Wall Street, they have to know a little bit about finance. And so they have to have more than just a minimal level of education to actually just be a civic participant in our democratic process, right? In terms of what's adequate, it's not really that hard to figure out for the states. And states after state after state across the country at the state level through school finance cases have had courts looking at these complex questions. So it really calls into question the assumptions that are in this case. They recognize that while there could not be a uniform or clear test, there's a wide spectrum that exists. Essentially, observing that the Act requires states to educate in a wide spectrum of children with disabilities. The benefits obtainable by children at one end of the spectrum will differ dramatically from those at the other end, and so there cannot be any specific ingredients that go into an IEP. And so we recognize that that's a fair claim. That's a fair claim. But in terms of the limitations of Raleigh, in terms of the limitations of the Andrew case, we have to be mindful of one thing, right? These students are depending upon the IDA, and the IDA has been touted in all of the public as, equality for students with disability. That's not what the IDA says. The IDA says that you get your foot in the door, you're good, right? Essentially, before the IDA was decided, before it was actually enacted, students with disabilities were just not educated at all, or they were left in the classrooms, waited until they grew up, and then they were kicked out or graduated or most likely transferred. So they were not really giving meaningful access in the same way as Lau versus Nichols students were, right? Those students were wholesale foreclosed from the education process. Recognizing that grade-to-grade advancement as FAPE was not quite clear, and the court refused to decide whether that would be the appropriate standard in this case. But the legislative history of this was not very supportive for the Andrew family. They wanted the IDA to say more. They wanted it to ensure that there would be promoting the child's maximum potential, or even providing for the well adjustment and for the functional and academic proficiency of the child. But what that meant for Andrew was quite different. They wanted this ambitious standard. But here's a question that we have to ask. What is essentially the protection? What is the protection when the school gets to decide? The school districts have the deference that are granted to them by the courts to determine what the IEP is and that that's adequate. It seems that there's an imbalance there. If we don't have recourse for parents to be able to push for some of their students to achieve maybe not to their maximum potential, but certainly more than just grade-to-grade advancement. Certainly more than just looking at the issue of keeping a child in a classroom for its own sake, or just to abide by the least restrictive environment provisions of the IDA. We want to make sure that they're meaningfully integrated into society, into the classroom, and to be socially well adjusted. But the court says, well, there's protection. The school district doesn't always have to decide. There is a protection in the IDA. You know what it is? It's parents. Parents are involved in due process procedures. They're very extensive, they're very intricate, and they have feedback in every step of the way. the parents are the feedback for protection. They before it gets to the Supreme Court, they have the due process hearing, they have the administrative hearing, they have to exhaust their remedies with the administrative law judge. But the problem is that you're presuming a family structure that isn't always there for everybody, right? That when you look at the dynamics, what happens, you have among low-income and minority students, referrals to special education happen by the teachers, where the students are put into special education, being stigmatized, not getting the benefits of these special education services, and we know this because they're not advancing. They're not, the academic achievement gap is just broadening, it's not narrowing. And they're not being functionally prepared to even just function independently in society as we would like. Compare that to Section 504 of the Rehabilitation Act, where affluent parents, they're the ones that are referring their child for those accommodations without the stigma of the IDA. They get the benefit of extra time on tests. They get the benefits without the stigma of the IDA. So when you look at this, we have parental referrals for Section 504 and teacher referrals for an IDA. But for the IDA, those referrals are from teachers who want to get so-called problem kids out of the classroom. And they're referring them to special education because of anything else that's not really a learning disability. And that's inappropriate and it's illegal to make those kinds of referrals. But those parents of those children tend to defer to the decisions of the school. They trust, in the communities of color, they tend to trust what school officials say and determine what is best. So it's not necessarily the best protection.
Sorry to interject. I think it's a good opportunity on that note. If we could take a step back, we'd love to get Professor Brooks up here just so we get some time. I think what we're starting to see is that the FBA did a great job of picking these cases because what we've seen is a common thread throughout, which is on education and how it's impacted by the Equal Protection Clause. And I think one of the other threads is Thurgood Marshall, who has had his hand in just about all these cases. And I think that might be a good segue if we could get to Professor Brooks and maybe get to some of the questions afterwards. Sorry to interject there. You just will have time to ask you questions and Professor Brooks afterwards. And I'll defer to him for discussion on Brown and the Bakke cases.
Thank you. I'll take about 20 minutes, and hopefully we can have some time for some interaction, questions, answers, that sort of thing. And I want to sort of warn you that I'm going to use these cases. I was assigned Brown 1 and Bakke as a basis for attacking sacred cows, and to give you a sense of the revolution in civil rights thinking that has taken place, at least in the law schools, similar to what happened leading up to 1954. There was a major change in the way in which we think about civil rights as a result of Brown, leading up to Brown, and a similar revolution is taking place today. So I'm going to use those cases to lay a foundation to sort of suggest that we might want to start thinking about how we want to conceptualize the Equal Protection Clause, equal rights, what have you, today. So in Brown versus Board of Education, Brown 1, the 1954 decision, not the 1955 decision, a unanimous Supreme Court answered in the affirmative the following question, quote, does the segregation of public education based solely on race violate the Equal Protection Clause of the 14th Amendment, close quote. Court answered that in the affirmative. The significance of the opinion, however, cannot be appreciated without some understanding of the socio-legal context in which the case appears, most particularly the Supreme Court's rather inglorious racial history of post-slavery. We're focusing post-slavery. We can go before the Civil War and find the same sort of Supreme Court. So the history post-slavery begins with the ratification of the Reconstruction Amendments to the Constitution, the 13th, the 14th, the 15th Amendment, as well as the criminal and civil statutes that Congress passed to enforce the Reconstruction Amendments. Now, rather than treating the Reconstruction civil rights laws as a mandate for promoting racial equality, racial advancement, the Supreme Court instead used these laws to shackle the recently emancipated enslaved to second-class citizenship, racial oppression. So the Supreme Court provided legal clearance for the enactment of laws throughout the South and for the establishment of customs in other regions of the country for the oppression of African Americans. The most famous example is Plessy versus Ferguson, which was decided in 1896, and Professor Dyson talked a little bit about that case. But in this case, the Supreme Court constitutionalized racial segregation, Jim Crow. And in so doing, it defined equal protection of the laws to mean separate but equal, separate but equal. Justice Harlan dissented in Plessy versus Ferguson. And he dissented on the ground that, quote, our Constitution is colorblind. But in the very same paragraph, he gave a glimpse of what life under the colorblind principle would mean for blacks and whites going forward. He said, quote, the white race deems itself to be the dominant race in this country, and so it is, in prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty, close quote. As I shall point out in due course, the colorblind principle has today become a principle of juridical subordination. It is a principle of juridical subordination in today's society, just as Justice Harlan prophesied, just as he prophesied over 100 years ago. So again, I'm going to circle back to that very important point. The majority opinion in Plessy rejected the colorblind definition of equal protection in favor of a more sinister, separate but equal norm. As a consequence, racial segregation, Jim Crow, became the judicial order of the day. I think it's important to understand that what I'm referring to here is not just Plessy alone, but the Supreme Court, its pattern of judicial decision-making. And Plessy is just one of dozens of cases decided by the Supreme Court after the ratification of the 14th Amendment that forced African Americans into a state of racial oppression. To quote one legal scholar, quote, the descent of the United States into enforced segregation into a nation where blacks could be tortured and horribly murdered without trial is a story profoundly tragic and profoundly American, and the Supreme Court was a central player in that tale, close quote. Beginning in the 1930s, two African-American lawyers who worked for the NAACP, Charles Hamilton Houston and his protege, Thurgood Marshall, filed case after case with the intent of making life under the separate but equal norm so expensive that the states would want to abandon it. This strategy did not work. But each Supreme Court victory chipped away at the separate but equal doctrine. Major cases like Missouri X-Rail Gaines versus Canada, McLaurin versus the Oklahoma State Regents for higher education swept the plainer. These cases all chipped away at the separate but equal doctrine. Then, at the trial stage of one of the 4 cases that was consolidated in what became Brown versus Board of Education, the NAACP attorneys heeded the advice of their law professor advisors, one of whom was a professor of mine at Yale Law School, and also the courageous trial judge presiding over the case, who dismissed the case with prejudice to allow Thurgood Marshall to refile it as a frontal attack on the separate but equal doctrine, a frontal attack on the doctrine. The result became history. The Brown court embraced a new concept of equal protection, to wit, equal rights, or what legal scholars refer to as formal legal opportunity. And in the decades following Brown, Congress and the Supreme Court fashioned a legal regime to give meaning to implement, to validate this new concept of equality, formal equal opportunity, a rather ambiguous concept. 2 potentially colliding norms came out of this process. Racial omission, which is Justice Harlan's colorblind principle, and racial integration. These norms perform rhetorical and regulatory functions. The racial omission norm simply means racial neutrality. That is to say that the government has to omit race from the formulation of policies, practices, and rules. Racial integration is simply racial mixing, that the government should support racial mixing in our major institutions, that integrated settings create opportunities for African Americans, and also remove the vestiges of separate but equal Jim Crow. Both the racial omission and racial integration norms presuppose racial desegregation, which is the removal of government-mandated, government-supported rules that stigmatize and that tell people where they can go and what they can do based upon their race. So in short, the racial omission and racial integration norms define formal equal opportunity ordained in the Brown decision, and that guided the Supreme Court in Congress in the creation of civil rights laws in the decades after Brown, and continue to do so today through the post-civil rights period. When we talk about civil rights, we usually divide it between the civil rights period, which ended about 1972 with the passage of the Equal Employment Opportunity Act of that year, and from that point forward, it's considered to be the post-civil rights period. But here's the rub. The racial omission and racial integration norms often collide. And that's precisely what happened in the case of Bakke, and also what happens in other voluntary affirmative action cases. The medical school at the University of California at Davis employed a 2-pronged admissions process for about 100 slots that they had set aside for each entering class. The first prong was a special admissions program, which was set aside about 16 places for certain minority applicants. And the second prong was the general admissions program, which was open to all applicants for the remaining 84 slots. Alan Bakke, a white applicant, was denied admissions, not once but twice. And he instituted an action for declaratory relief and injunctive relief against the regents of the University of California, claiming a violation of the Equal Protection Clause and also a violation of Title VI of the 1964 Civil Rights Act, which prohibits racial discrimination in programs or activities that receive federal funding. Justice Powell delivered the opinion for the court, in which he said, quote, "For the reasons stated in the following opinion, I believe that so much of the judgment of the California court," this is an appeal from the California Supreme Court, "as holds petitioner's special admissions program unlawful and directs that respondent be admitted to the medical school must be affirmed. For the reasons expressed in a separate opinion, my brothers, the Chief Justice, Mr. Justice Stewart, Mr. Justice Rehnquist, and Mr. Justice Stevens concur in this judgment," close quote. So Powell is saying that the special admissions program was unlawful because it was based upon a racial quota. The racial omission norm trumps the racial integration norm. But then he went on to say, quote, "I also conclude, for the reasons stated in the following opinion, that the portion of the court's judgment enjoining petitioner from according any consideration of race in the submissions process must be reversed. For reasons expressed in separate opinions, my brothers, Mr. Justice Brennan, Mr. Justice White, Mr. Justice Marshall, and Mr. Justice Blackmun concur in this judgment," close quote. It was a complicated opinion, to say the least. But that part of the opinion basically says that the racial integration norm trumps the racial omission norm, where race is but one factor that drives the admissions decision, one factor that drives the admissions decision. And the court mentioned the Harvard program with approval. So Bakke stands for the proposition that racial quotas are unlawful, but racial preferences are not. And this is the law of the land today, although only by a narrow margin. The Grutter case and then the Fisher II in particular, sort of basically the embodiment of Justice Powell's opinion in the Bakke case. Now, for most civil rights scholars, Bakke is viewed as a major setback in racial progress. And there's all kinds of reasons for that. And in one of my books, the Racial Justice in the Age of Obama, I have charts, about 100 charts, and I sort of look at the racial dynamics and demographics from the end of the civil rights period to today, or to 2006. The book was published in 2009. And one of the things you see is that in the mid-1970s, the college participation rate for Black and Latino students was equal to, and even a bit higher than, the college participation rate for white students. This was pre-Bakke. After Bakke, the college participation rate for Black and Latino students steadily declined, so much so that it has been for decades now the lowest college participation rate. And there are others. You can look at, Bakke had a major effect, not just on education, but across the board in employment in particular. Okay, so we have three ways of defining the equal protection clause historically. There is separate but equal, there's the racial omission and racial integration. Now, what I want to do now is just to sort of take you into what's happening in legal scholarship today in civil rights. These post-civil rights definitions of equal protection are being challenged. In other words, this notion of formal equal opportunity, it's still used today. It's really a civil rights concept, but it's still used today. The Supreme Court, that's the court in this racial omission, racial versus racial integration vortex, and they can't seem to get out of it. Although there's some sense that Kagan and Sotomayor might lead the court out of that once they become comfortable on the court. There has been a challenge to formal equal opportunity, to this notion that we define equality in terms of color blindness or racial integration. And the challenge has gained momentum in recent years by movements like the Black Lives Matter and by the Me Too movement. And it defines, the challenge defines equal protection not as the achievement of a colorblind America, not as an integrated America, but as empowerment, as social transformation. And this new view of equality is premised upon an empirical observation, to wit, the problem of race has much to do, if not all to do, with the relationship between race and power in our society. The problem of race has to do with the relationship between race and power in our society. Look around, what do you see? Whites are on top and blacks are on the bottom. And that's not a natural process there. Now, it's constructed. The problem of sex is a function of the relationship between sex and power in our society. Men have it and women do not. The Me Too movement is trying to take that away from men. And so Justice Harlan was right when he prophesied over 100 years ago that a colorblind constitution will not change the racial dynamics in the society. Whites will still be on top, and that's how it is today. So in 1954, the challenge for civil rights scholars, for jurists, for practicing attorneys, was to construct a legal regime around the formal equal opportunity norm. Use the law to validate a new concept of equality. Likewise, the challenge today is to construct a legal regime that validates empowerment of racial minorities and women. That is to say, a new concept of equality, a new way of reading the Equal Protection Clause. So what I'd like to do is to leave you with three thoughts from three different Supreme Court justices that might guide us in the construction of a legal regime that can validate this new norm of empowerment. And each of these thoughts that I will present really speak to the symbiotic relationship between law and society. The notion that law is valuable because of what it does. It has an instrumental value. That law is not a museum piece that you look at and you admire for its intrinsic beauty. It does something. That's why it's valuable. The first justice is the great Oliver Wendell Holmes, who wrote, quote, "The life of the law has not been logic, it has been experience." When Judge A. Leon Higginbotham gave the commencement address at our law school back in 1982, he mentioned this particular quote, but he changed it. He says that the life of the law has not been logic, it has been values. So the question is, whose values will the law vindicate? Is it going to be the values of women, minorities, or the values of white men? Whose values? Are there common values that the law can validate, which will give us decisions that represent good social policy? In similar fashion, Justice Marshall wrote, quote, "What is striking is the impact legal principles have had throughout American history in determining the conditions of Negroes." Justice Marshall uses the word Negroes, and every time I teach his cases, I got to remind my students not to get so caught up on language. Okay, you know, he doesn't use the word black or African Americans, but he's a great justice. And finally, Justice Felix Frankfurter wrote in one of his opinions, quote, There is no greater inequality than equal treatment of unequals. No greater inequality than equal treatment of unequals, close quote. So what I want to do is sort of stop here to give us a chance to have a Q&A and just to recommend that you begin to think about what's going on in legal education. The old notion, integration and colorblindness, that's sort of passé, and the law has to catch up with that. And just as the law had to catch up with the new concept of equality back in 1954, same process is going. This is a marvelous time to be in law school because civil rights is really changing, absolutely changing. With that, I will thank you and I will sit down.
Thank you both, Professors Dyson and Brooks. And as you can see, we are so rich with material here that we could really spend all our time on any one of these cases. What we're hoping to see is that there is this common thread, both the development of the law under the Equal Protection Clause and how it has changed both up and down as far as how it concerns race, primarily in these cases, and education. I want to open it up to the audience for questions. I think I'll start it off for both of you. Professor Dyson, you mentioned how social science really came as an issue in the Mendez case, and that laid the groundwork in Brown versus Board of Education, where the Supreme Court, really looked to the psychological effect of segregation on black kids at that time. Of course, Mendez, it was the Mexican American kids. We see that throughout the litigation until we get to Lau and Andrew, and we're talking a bit about kids that feel, in the case of Lau, the Chinese-speaking students, that maybe their feeling of inferiority is just because they can't speak English, and Lau, of course, the disability. For both of you, how much has the idea of using social science been as a replacement or a supplement to look into legislative history, congressional intent, and how much has it been ignored, especially in light of Bakke, where it seems to be thrown out the window?
Again, as I pointed out before, that famous footnote 11 in Brown versus Board of Education, looking at the Kenneth Clark Doll test, that was, that was following the idea of sociological evidence being introduced into court cases, and I think that's important to continue to do, because if we do, it will point the way to the right result. So, for instance, as I mentioned before, the cognitive implicit bias is important. Our whole jurisprudence on the 14th Amendment is based upon finding the intent to discriminate. But if the person doesn't even have the intent to discriminate because they don't even know that they have racial bias, what kind of help does that model? So I hope that we actually use social science evidence more in our legal jurisprudence, because I think that would help us point to the right way. When we look at how, for instance, the science data says that, juveniles, for instance, who are brought into interrogation in the police interrogation rooms, they are there for hours and hours interrogated, and they admit to crimes that they did not commit. And now, officers are saying, well, we saw you on camera, and that's perfectly allowable, right, under the Supreme Court case law. But it's unfathomable to people to think that people would admit to crimes that they did not commit. But the social science data shows that it happens all the time. It happens all the time. And our case law has not caught up with that. So I think if we stick with this, I think, as I said, the social science data will point us to the right direction. I just hope that we truly embrace it, because right now the law is falling behind.
Social science was introduced into legal analysis in the famous Brandeis brief in Miller versus Oregon, where about 98 pages of the brief was social science, and 2 pages were sort of legal principles. And social science data, of course, is threatened by the whole notion of originalism. And the originalism states that the Constitution should be read as sort of a dead Constitution, the meaning taken from 1791, which is when the Bill of Rights were sort of ratified. And of course, the late Justice Scalia has popularized originalism, and at my own law school, we have the Originalism Institute there. And my own views is that that originalism is kind of a subordinating concept, because it's asking women and African Americans and the LGBTQ community to accept constitutional meaning from a time when blacks were enslaved, women were second-class citizens at best, and the LGBTQ community was not even allowed to exist. That's sort of a little nutty and slutty in my view. It's the only theory that allows the dead, to bury the living. And so that's the threat to social science. And I do, all of my scholarship is interdisciplinary, because you can't do legal analysis without looking at the subtext, and the subtext is usually social science, it is threatened by, there are concepts in law which threaten the use of it, but I hope that it will continue. It's just too important not to.
In Mendes, I believe it was, they pointed, of course, to Plessy, and saying that there was no idea of what education was in American society, so therefore we should look at psychology. In Bakke, they said, well, the founders probably meant to have the 14th Amendment apply to African Americans, but we're going to ignore that here. Was that a bit of judicial activism, or how would that play in that analysis?
It's interesting because, I really love reading Justice Scalia's opinions, because there's a lot in it, that very enlightening, and some of it makes you chuckle. It's, he says in one of his dissenting opinions, where, under the Equal Protection Clause, you have these 3 levels of judicial scrutiny. He says, well, the court really sort of uses a level that sort of fits its particular purpose in a particular case. And so that's a great admission to have. And so, I don't know, this whole notion, what we have to do, I think, is we just have to be generous to ourselves, and don't get caught up with this legalistic stuff, because it only comes after the jurist determines where he or she sits with respect to these very fundamental questions about race and gender. I'm talking about the civil rights context. And I just think that a lot of what goes on in these cases is rather hilarious, but very important, and you can't ignore it. You have to deal with it and try to make sense of it. And I'm always reminded of the famous statement by Justice Rehnquist. He says, "Look, if you want to find logic and reason in our opinions, just consult the law reviews."
I want to, before I look for more questions from the audience, kind of ask you, Professor Brooks, you said it's a great time to be studying civil rights because of where we are. These cases here, it seems like, at least the analysis of education and the Equal Protection Clause, how it applies there, has changed from in Mendes and Brown, where segregation was unlawful on its face, to we start from a right to education to a right to a quality education, or a right to progress under Lau and Andrew. And by the time we get to Andrew, there's not even a mention of the Equal Protection Clause of the 14th Amendment. How do you both see this developing? Is this a good thing, a bad thing in the larger picture, or is it that just we're concentrating on more minute issues?
So, I think it's troubling, to be quite honest, because, and I see this with the school finance cases I do, we have moved from Equal Protection Clause jurisprudence, where the Supreme Court in Rodriguez in 1973 said it's not a fundamental right. And so it foreclosed the federal option of actually trying to have equal parity in funding. to having the states to now try to fight for an equal protection clause and then having that fail as well. So now we've moved to an adequacy standard. Is the education simply adequate? And I think that there's something that gets lost when we move from an equal protection standard to an adequacy standard, because we fail to realize that adequate to what is going to always be measured by the opportunities that are available to each of these students. And they're not equal. They're not equal. We don't have the same equal ground. So I think that's problematic. And with Andrew, it's interesting because, as I said before, what progress is there? They can't really define what is a tenable standard to articulate. But from Menendez, it was always comparing the Mexican students to the non-Mexican students in terms of meaningful access to education. And looking at Lao, it was the same thing. Looking at students' ability to have a meaningful education compared to their to their native English-speaking students. And when Amy Raleigh and, of course, Andrew S. parents were trying to advocate for a similar standard, we want to have meaningful access based on the same standard compared to their non-disabled students. It doesn't necessarily mean that that we're going to have to have a uniform standard for every child. Every child is individually unique. But what it does mean is that we have to hold up to that ideal. We have to hold up to that standard. Because if we lose sight of that standard, we are mired and lost. There's no way to have measurable goals that are meaningful, right? In terms of providing a student to have meaningful access, whether they're disabled, whether they have language proficiency issues, or if they're of a different race. What it means to have a quality education is to provide opportunity. But it's not just opportunity. The rhetoric has been, equal opportunity means equal access. But equal opportunity also has to do something, have something to do with results. It has to have something to do with outcomes. And one benefit, at least with the school finance case, is that we look at the outcomes. Are we getting the kinds of outcomes that we want? And that's what Andrew's parents were trying to say. We're getting the outcomes that we like here. We weren't getting it before, right? So I think we can do better, but we have to fall away from this rhetoric that equal opportunity just means equal access without any regard to outcome. I think that's that's the ultimate fight we're having.
I agree, and again, it's and I'm talking about really the Supreme Court that has the latitude. I mean, I clerked for a district court judge, and I know that your hands are tied by precedent and especially precedent of the circuit and all. But the Supreme Court justices have a lot of latitude, and so this just sort of speaks to their exercise of their ability to decide what legal standards will apply and be damned with the consistency, and so I can tell you it's really hard to teach this stuff because the students come in thinking it's the law and they think of this sort of a syllogistic kind of analysis, and it just doesn't work, and it's not political, it really isn't, because these judges have, judges, they're not really acting in a political fashion. Some are, but not necessarily, and it's just that they have deep convictions about the issue of race. Some justices feel that race no longer matters. Justice Roberts says that all the time. Race no longer matters. And then there are others, justices who believe, race still matters. And then there's Justice Thomas in educational cases involving historically black colleges, universities. He's very supportive. And in Jenkins 3, he has a statement, and never ceases to amaze me that judges think that anything that is black is inferior. This is a Supreme Court justice saying that, okay? And so these judges do act out of their convictions. And we all know that. That's why we spend a lot of time over who gets nominated to the Supreme Court. If that didn't come into play, we wouldn't spend so much time on it. But we know that it does matter who decides.
Are there any questions in the audience? Yes.
Yeah, hi. Thanks for the time, by the way. This is great. I wanted to come back to the juxtaposition of the impact of social science that it sounds like we accept has a big role with the concept of values and you know, separate not being equal and whatnot, particularly when it comes to gender. Because there's a lot of social science, good social science, I'm sure there's some that is on the other side, that suggests, for example, that in certain circumstances, single-sex education is very beneficial. And I know that the public schools have tried to experiment that a lot in Detroit and other places where, in inner cities where there's a huge problem, you need male role models or whatever, and yet they've been consistently struck down because of the equal protection clause. And yet the social science is telling something different. So I'm curious to know how the panel feels if we believe in social science, but we don't believe in separate but equal. Which of that? And of course, we're worried about values.
Sure. Yeah, and I got you. It is because of the judge's deep conviction in the racial omission tenet. That is why we allow single-sex schools, but not single-race schools or for black boys. You know, and as a matter of fact, the NAACP has been on the forefront in bringing actions against such schools. And yet, no, the social science data is there, but the justices can't get beyond their core beliefs. And I don't know how to crack that. You know, right now we do it by making sure that we have, quote, the right person on the court. But at some point, and they've got to come to the realization that it's not about them, it's about the country and what's good for the country. It's about good social policy. That's what it comes down to.
See, but what's good for the country, as you said, it's about values, right? I mean, that was a great modification of that Alderman O'Connor's quote. You know, it comes down to values. And I can tell you, and it's true, every constitutional scholar can point to every case and they can tell you how it's going to come out. Because if you're looking for a uniform theory of jurisprudence for the Supreme Court, it's to protect privilege. It's to protect advantage. And when, as you saw before in the Bakke case, where college attainment was starting to rise above that of whites, that's when this case, was stricken. That's when Bakke, of course, put a nail in that and said no, right? When you start to get to that level of progress, that's when parents involved in the committee versus Seattle School District, the Supreme Court says no, you can only go so far, because and this is embodied in the equal protection jurisprudence under narrow tailoring analysis. Under narrow tailoring analysis, it is unconstitutional if any kind of remedy has a disproportionate or undue burden upon non-beneficiaries, meaning whites. So every case that you look at, I can tell you how it's going to come out, because if it threatens privilege, if it threatens advantage that a group of parents or families have carved out for themselves within the school system, that's going to be preserved. And if the school district tries to pass some kind of pupil reassignment policy that tries to threaten that or challenge that, it's going to be stricken down. And I challenge you to find any other way to look at these cases where they can be harmonized in that same fashion, because that's the only rationale that you'll see between case after case after case.
I just want to circle back to the question you asked before. I forgot to mention this about social science data. We also have to be careful about the use of social science data. I remember I was writing an article about 1995, and I had my research assistants. By the way, I have really great research assistants. I had this new book, and I was being interviewed, and they asked me, how do I write so much? I had a good research assistant. Mr. Tenorio was a research assistant. Mr. Kim worked on about, 3 books. Wore him out. So I have my research assistant, and I tell them, give me everything out there, and so they keep me busy reading. And so I said, I want to see the Dow test. I want to see the study. And so she got the study, she wrote me a cover memo and all, and it was just, saying that. And then I looked at it, and I went back to, didn't you think I was going to read the Dow study? Because when you read the Dow study, it actually says that black self-esteem is higher in segregated schools than in integrated schools. And that stands to reason, because in integrated schools you're getting beat up, all the time, and the segregated schools, you have a more harmonious environment. And so we have to be very careful about social science data. And the question, that sort of recurring question there, is whether or not, obviously the Supreme Court justices, or maybe they did, maybe the case didn't read the study, we don't know. But the question is whether or not the NAACP lawyers had an obligation to present the study the right way. Was the fight against segregation so important that it justified the manipulation of the data? Those sorts of things, questions. So all I'm saying is that we do have to be careful about social science data. I mean, some of the data before said that, blacks are inferior, and biologically so. So we're not saying we can't use it, but we have to use it in a very responsible way.
I want to get us to the reception soon enough, but I know we have a couple more interesting questions. Sir, go ahead, and we'll go from here.
You mentioned Rodriguez, which is Rodriguez versus the San Antonio Independent School District. And it was, a poor district on the south side of San Antonio, heavily Latino, and a basically white suburb, Alamo Heights, and disparity. In California, at least, you have Serrano versus Priest, which comes to the opposite result. And I guess my question is, has it really made any difference?
No, like I said before, it's not going to make a difference because our jurisprudence is compartmentalized, right? So you can't deal with education without, look, if you try to desegregate education, that's not going to be effective without desegregating housing. There was a nexus there, right? And Milken versus Bradley severed that nexus. So, it was already doomed to fail. But, as I said before, you got to look at, the outcomes in these cases. What's the outcome that you want to achieve? And the school finance cases are looking at the outcomes. They're not just saying equal access is enough, right? We have to look at the outcomes. That's what Andrew F. was asking for. That's what these other cases are asking for. But often the outcomes are shaped by majoritarian, interest. That's the theory, that's the revelation we got from Derek Bell and the interest convergence dilemma. Brown versus Board Education, you can decide and talk about social science all day long, but to be quite honest, the decision was also in part decided because we were fighting a Cold War with Russia. We were trying to fight, the ideological battle. The African nations were declaring their independence from colonialism, and there was a concerted effort to actually, have, America look good overseas when Malcolm X threatened to take the country to the United Nations for human rights violations. That would be a big black eye in our face when we're trying to tell the rest of the world how great we are and how they should be. So, that outcome was shaped by majoritarian interests. And the moment that it stopped serving majoritarian interest, that's when you started to see a regression, a retrenchment back into where we are today, where resegregation is greater now than we had before.
As a matter of fact, the State Department issued a supporting brief in Brown, in which it said that segregation is hurting the Cold War effort. So those materialistic concerns. But your question, even school funding is based mainly on property taxes, and even if you were to smooth that out, you can't stop the inequality, because you can always have parents in La Jolla, they can, with their booster clubs, they can bring in money, that sort of thing. And so I remember when I was a law student at Yale, and we had this person come in and talk about that. He says, the solution to this whole problem is to get rich. That's it, get rich. That's the solution to the problem, just get rich, make money. And because the best place to find a helping hand is at the end of your own arm.
Well, let me just give you one last thought. And this comes from the Bollinger cases. We saw the military and Fortune 500 companies get together with civil rights groups and military journals. That was an interesting interest convergence, right? When we can articulate that there is a business interest in having diversity, there is a business interest in having equality, and those arguments are paramount now, because most of the business is coming from non-white communities, and that is the new business model that everyone is recognizing. So I think we need to articulate that, that is And it's going away from the ideal of egalitarian equality, but it's making the more practical argument, I suppose, that there is a legitimate business interest for you to do what you need to do. And when we make that argument and make it effectively and bring that to the courts, that is what they listen to, and that's what's been effective. So, I think there's more than one way to skin a cat on this.
Before we end, I just want to suggest if you're interested in sort of following this development in terms of the revolution in civil rights thinking, I would recommend, obviously, chapters 1 and 2. This is Racial Glass Ceiling, which was published by Yale University. But I go to the library because I'm not into peddling my own stuff. I go to the library and just Xerox or copy chapters 1 and 2, and that will give you sort of a sense of it. If you can find the chapters online free, do that. But that would give you a sense of what's happening in terms of this revolution in civil rights thinking.
We'll leave it on that note. We want to get you to the reception. Hopefully the professors will be here if you have individual questions. I want to thank you, and I want to turn it over to Crystal to give us final words.
Thank you all for staying a little bit over. I know it's a Friday evening, so I appreciate it, but I hate to cut off this engaging discussion, but please move into the other jury lounge. There's refreshments, food and drink in there, so continue the discussion between yourselves, between the professors. There is different exhibits set up. Please take a second to look at those. I'm also going to bring in the materials covering the video and the essay contest. And once again, thank you all for being here on behalf of the District Court, the FBA, and the Federal Judges Association. Thank you.